I'm really excited that you're here to join us for the class tonight. This is going to be a 22-minute pre-recorded class. Tonight we're talking all about estate and legacy planning and how to keep your family out of court and out of conflict. This is a serious topic and one of the most important topics you will consider. My name is Carol Lawson and I am an estate planning and probate attorney in Clearwater, Florida. We serve families in all counties throughout the state of Florida virtually via Zoom and have offices in Pinellas County, Florida. Tonight, I'm going to teach you all about how you can put in an estate plan in place that'll actually work when your family needs the most. I just wanted to say thank you for joining me on this presentation. If you call our office and mention this presentation, we will schedule you a free 15-minute call with me to talk about your situation and the people you love and how we can protect them. The reality is that estate planning is not about you. It's about providing for the people you love. I help families create a plan that will work when your family needs it to and will keep them out of court and out of conflict. What happens to your family if you have no estate plan in place, or only a document here or there, or maybe an outdated plan that hasn't been looked at in years? What happens when you're either incapacitated or no longer around? How vulnerable is your family? Will there be problems? Which is why a personally tailored estate plan can solve all of these problems by keeping your family out of court and out of conflict. I just want to give you a little bit of background about who I am and why I practice estate planning law. I become an estate planning attorney because I have been in the exact position that you never want your family to be in growing up. Estate planning resonated with me. My parents were divorced when I was 7, and my father died without a signed will when I was 16 years old. I then spent my senior year of high school and first part of college in Detroit, Michigan's probate court, fighting his relatives, and an attorney with an alleged unsigned will who wanted to be appointed custodian of the estate funds and my inheritance. Years later, when I went to law school, I was talking to my estate planning and tax professor about my dad's probate estate. If my dad's so-called attorney had created a trust, and my dad had transferred his assets into the trust to make it work correctly after the plan executed, years of litigation could have been avoided. Our firm does not just put in place one-size-fits-all Word documents. We will help you fund your plan and transfer your assets into the trust we set up for you. I made a commitment to never let my clients suffer what I suffered to create something truly meaningful for my clients in the form of estate plans that would actually work when their families needed to and provide the best client experience while doing so. We will file your deeds for you in Pinellas County. If you bring your beneficiary forms into the office, we will help you complete them. We will draft your deeds assignments and help you set up ABLE accounts if needed. Let's discuss some sample scenarios. The first is a family of 3 on vacation, a mother, father, and their child, the Horns, visiting their best friends in northern Michigan. The family has a serious boating accident in Torch Lake. The father dies on the scene, and the unconscious mother is airlifted to McLaren Northern Michigan Hospital. The police turn the child over to Children Protective Services and contact their friends, Linda and Ed, who were listed as the couple's emergency contacts. Linda calls the husband's sister and wants her to pick up the child and care for him until the sister, Jennifer, can arrive from Florida. Linda will just take the child and look after him in the meantime, right? Wrong, Linda can't take the child, you see, until the legally nominated guardian comes forward. The child must remain with Child Protective Services in a strange state with people he does not know. The police and CPS ask Linda if she's the legal guardian of the child and if she has any paperwork to prove it. She tries to explain that she's a longtime friend and the child knows her and trusts her, and that the father's sister, Jennifer, is on the way from Tampa. The child confirms the family's relationship with Linda and Ed and that they are staying in Alston with them and that he wants to go with Linda. Sadly, the police have to inform Linda that the child will need to be placed in the care of strangers until the child's legal guardians can come forward or one will be nominated by a court. If the mother was conscious, she could tell the police to turn her son over to Linda and ED, but she can't communicate. She's incapacitated in a coma in the hospital. They had no will in place or any other documentation that nominate a legal guardian for the child either. So now the sister Jennifer will have to be nominated by a court in Michigan to be the child's legal guardian and take her back to Florida. If you're a parent with minor children, this would be one of the scariest scenarios you can consider. I mean, can you imagine how traumatic that would be for a small child to go through? Our child protection package includes a short-term guardian nomination document for the child and a pre-needs guardianship document for each of the parents. We would have had the couple nominate temporary guardians like Linda and the sister to be able to act as first responders and quickly arrive on scene in emergencies, take legal custody of the kids temporarily until the parents recover or the court sets up a permanent guardian if they die. That way, your children are always with exactly who you want no matter what. Copies are given to the temporary guardians, including electronic copies of the documents. So, Linda could have just pulled up the short-term guardian nomination document on her phone, showed it to the police to allow them to let her take the child home. Let's say the mother lives, never remarries, and never does any estate planning. So when mom dies and the son calls the office and we have to explain he is going to have to go to probate court because mom still owned all her assets in her personal name. If you die still owning assets in your personal name, then your family has to go through the probate court process in order to legally get ownership of the assets you leave behind based on your will, which says who to give your assets to, or if you don't have a will, who the state law says to give your assets to. So mom died owning her $600,000 home, $500,000 in a 401k with son named as beneficiary, and a $100,000 money market account with no name beneficiary. All assets still in her personal name, the now adult child will need to spend the next 9 to 18 months or longer in probate court to get ownership of the home and the money market account. So instead of just being able to grieve his loss of his mother, he is now dealing with this legal mess. The probate court process, when you add up all the fees that are involved with the probate court proceeding, from attorney's fees, personal representative fees, bond fees, publication fees, court costs, etc., can be quite expensive. The fair market value of the probate estate in this scenario is $700,000. That's the $600,000 home and the $100,000 money market without a named beneficiary. In Florida, the average probate attorney fee cost in a formal non-contested probate is 3% of fair market value of the estate, so in this case, $21,000. Assuming we are in Pinellas County, the filing fee is currently $400, and the publication fee for the court observer is currently $155. So to even open up the case, the son is going to need $21,555. But the cost doesn't end there. The court is going to require a bond, and he is going to have to pay a fee for that. Also, if his mom didn't appoint her son as the executor in her will, then whoever is the executor of the estate can also take a fee for the administration of the estate. That's another 3% of the estate, or $21,000 the son will not receive. If the son is the executor, he may also take the fee before any creditors are paid in the estate. He can also recover all of his expenditures involving the estate prior to creditor or beneficiary distribution. So as of right now, the $700,000 estate has paid out $42,555, plus let's say $500 for a bond, for a total of $43,055 as their one claims and expenses. The estate value is now $656,945. Since the mother was resident of Florida, the house was her homestead, and the son can apply for the homestead exception, which means the $600,000 home will be transferred to him free of most of his mother's creditors. This would not apply to mortgages and a few other situations like homeowners associations, property taxes, and the likes. So the value left in the estate is $656,945 for both beneficiaries and creditors. Assuming no claims are made by the IRS or the Agency for Healthcare Administration, or repayments owed for Social Security or EMS or other government agency claims, the next level of claims would be the mother's credit cards and utilities. Let's say that they totaled $20,000. The son, as beneficiary, now receives $16,945 of the original $100,000 in the money market account as beneficiary. The son will receive this outright from the probate along with the real property. He will own his inheritance in his personal name without any restrictions or protections in place. So if your child receives their inheritance outright in their personal name, then up to 50% of their inheritance could be taken away from them if they ever got into a future divorce and had commingled those assets. Also, if your child was ever facing a lawsuit or bankruptcy proceeding, those lawyers and banks could take anything under your kid's personal name with some exceptions. Currently in Florida, the equity in your home is subject to limits based on how long you have owned the property. You must have owned the property for 1,215 days, approximately 3.3 years, to receive protection for all the equity in the home under Florida law. Otherwise, as of this writing, you are capped at $125,000, or under the federal exemptions, $189,050 till March 31st, 2025 if you don't qualify for Florida exemptions. So how can we fix this? We can fix these concerns through proper estate planning. Instead of dying without any estate planning, let's say mom came to my office after she got out of the hospital. Mom did her estate planning, reviewed it yearly with us to make sure all her assets were transferred into the trust, and amended the trust as needed. We helped her set up a revocable trust so her son, the successor trustee, can now avoid probate. If you put your assets into a revocable trust, you have full control of the trust during your lifetime. Assets you own, like your home and money market accounts, are taken out of your personal name and put into the name of your living trust. And real estate trust, or the trust, is named as the beneficiary on the financial accounts. You have full control over the trust, and when you pass away, all of your assets, which are owned by your trust and not owned in your personal name, got to your beneficiaries. There's no need for your family to go through probate court. In our next fact pattern, we helped to transfer all of his assets into his trust, so that way when Mark died, his home and money market account were owned in the name of his trust, and his 3 adult children were able to receive ownership of those assets in a matter of weeks in the privacy of my office. No 9 to 18 months of probate court and no probate costs, just trust administrative attorney fees. One of the biggest mistakes people can make right now is to just have a will. A last will and testament does not avoid probate court. If you die with a will, you still die owning all of your assets in your personal name, which means your family still has to go through the long and expensive process in probate court. Only a trust where all your assets are owned by the trust is actually going to help your family avoid the probate court. Instead of having Mark's kids receive Mark's money from the trust outright in their personal name, we're actually going to have the kids receive their inheritance in the name of their own lifetime asset protection trusts that they are the trustees of. So that way his kids' inheritance is protected from any future divorces, lawsuits, or bankruptcies they may get into. A trust just makes things way easier on your loved ones after you're gone and allows them time to just grieve their loss of you in peace rather than dealing with a long, expensive mess probate court after you're gone. Let's say you got in an estate plan in place that kept your children out of court and kept them out of conflict with each other after you're gone. Now they're really going to want for the rest of their lives is something to remember you by. Your legacy, and I'm not talking about your money, I'm talking about is your intellectual, spiritual, humor, who you were as a human being, and what was important to you. It's about your loved ones having your values, your stories, and your experiences as a way to remember you. ARC can help our clients prepare a video for their family so that they can transfer memories to their loved ones if you are interested. This is important, especially if you have young children. I am bringing this up. Look, I don't have any videos or audios of my dad. Okay, I have pictures, but I don't have recordings. He died when I was 16, and as time goes on, it just becomes harder for me to remember him. I'll never truly know my dad, and it would have been really nice to pull up a private video or audio recording that he just made specifically for me, just to tell me who he was, what was important to him, and just what he wanted me to know in life. There's a lot of information that I've shared with you tonight. There are a lot of things that could happen to your family. For example, if you become incapacitated, who look after you if you do not have an estate plan in place? I mean, you've seen from the story of the Horn family, how serious the financial and emotional consequences can be on the loved ones that you leave behind. And for those of you who do have an estate plan in place, maybe get a review. Some you have old estate planning documents from over 10 years ago. Forms change, children grow up, beneficiaries may die. You've seen from my own story about my father's failure to have an estate plan, how the typical one-size-fits-all solution that most traditional estate planning law firms or the do-it-yourself online software provide, you are just going to leave your family at risk now. If anything I've talked about tonight has you starting to think, what will happen to the people, what would happen to all of my assets if and when something happens to me? Would my family end up in court? Would my assets potentially be lost? Would my children's inheritance be at risk of being taken away if they ever got a divorce? I want to give you a way to get answers and solutions personally tailored to your family, and that is by scheduling a one-on-one 15-minute discovery call with me. This is a free 15-minute discovery call where you and your spouse, if you're married, can hop on the phone with me so we can discuss your estate planning goals and determine how I can help you on both. Have your spouse on the line because I'm going to be representing both of you. I need to make sure that we are all on the same page. You can book free 15-minute call with me at 727-410-2705. I do want to get into pricing because pricing is important. A fully comprehensive estate plan costs anywhere from $1,500 to $10,000 depending on your family's needs. You might need LLCs, a sub-S corporation, multiple real estate trusts, or a special needs trust, in addition to your revocable trust, or you might need a Medicaid trust. Every family has different needs and different estate planning goals to accomplish. You might only need a will and a ladybird deed. Some of you will need only wills and powers. Some will need trusts. Some will need powers of attorney. Some may even need a combination of all the above. So I can't tell you exactly what your family's estate plan is going to cost here on this webinar because I just don't know exactly what you're looking to accomplish. So that's why if you schedule your free 15-minute discovery call with me, I'll be able to ask you a few questions about your assets and what you're looking to accomplish. Then we'll be able to narrow down the range of what you could expect to pay before we take any further steps. Your discovery call with me is completely free. It's simply an opportunity for us to speak so I can ask you about your goals, explain our process of how we will accomplish those goals, and give you clarity on what you can expect. I only open 8 free spots for discovery calls open with me each week. So if you're interested in taking advantage of this opportunity and finally getting the answers you'll need to put the right estate plan in place to protect your family, then you should schedule your free 15-minute discovery call now. I know that some of you probably have questions based on what discussed tonight, so call 727-410-2705 to schedule your complimentary call.